Good morning, everyone. मेरा नाम साक्षी शर्मा है and I'm the founder of Legal Vidya. So today on our website, on a platform, we'll be sharing a few topics with you जो आपके लाइफ में कहीं ना कहीं आपको काम आएंगे if you are from law background or even if you are not from law background. The topic for this presentation is how to do legal research and essay writing slash article writing. सो जो लीगल रिसर्च है या फिर जो इन जनरल रिसर्च है और आर्टिकल राइटिंग की बात है, दिस इज समथिंग विच वी ऑल कम अक्रॉस अ लॉट इन आर डे टू डे लाइफ्स. Whether you want to participate in an article writing competition or an essay writing competition, you want to do an internship, or if you want to write a blog, say for example, or you want to present a thesis or a research paper, in all such cases you'll have to know how to write and what to write. So first we'll be dealing with the what to write wala part, and then we'll go on how to write. That brings us to the first part of our presentation, that is what is legal research. Now I have defined legal research, as you can see on your screens, as the process of identifying and finding information necessary to support legal decision making. It is generally the process of checking for a legal precedent that can be cited in a brief or a trial. Virtually every lawsuit, appeal, criminal case, and the legal process usually requires some amount of legal research. Legal research skills are of great importance for lawyers to solve any legal case, regardless of area or type of practice. The most basic step in legal research is to find a noteworthy case governing the issue in question. So, when you're doing a research, you'll be known as a researcher. So, a researcher's analysis of the case, it often begins in the initial stage where he or she identifies relevant facts and determines the legal issue or question that he or she wishes to research upon. Now, as this analysis continues, it is further refined as they decide where, how, and what to research. So, first you find a question governing the case. Until and unless you have a question, आप research किस पे करोगे? So the first step is to find a question, and then you have to decide कि आपको उस question में किस aspects को deal करना है, which comes to the question of where, when, what, and how. Now, once you find relevant legal material such as case laws or obiter dictas or any books citings, then you need to understand them, and then you need to see how can they be applied to your case in hand. Now, this research provides a crucial analytical foundation that will aid you in your decision for the remainder of the case. Whether you're a lawyer, a paralegal, a law student, or even if you're not from law fraternity, it is essential that research is done in an effective manner. So that is where the methodology part comes into play. Now, every case is different from one another. The case which you are dealing today might not be the same tomorrow. एंड सिंस दोनों केस ही अलग है, दोनों में लीगल रिसर्च करने का अप्रोच भी अलग होगा. दैट ब्रिंग्स मी टू द सेकेंड पार्ट ऑफ आर presentation, that is types of research. Broadly speaking, the types can be classified into two, the first being doctrinal and the second being non-doctrinal. तो बिफोर अंडरस्टैंडिंग डॉक्ट्रिनल रिसर्च देखते हैं कि वर्ड डॉक्ट्रिन उसका मतलब क्या होता है. Doctrine is a rule or principle of law established through the repeated application of legal precedents. A legal doctrine is a framework or set of rules or steps or tests that is often established through precedent in common law through which judgments can be determined in a given legal case. Since if you're a law student, you might come across the word doctrine a lot. For example, company law का ही example ले लो, that is the topic of doctrine of indoor management. ये क्या होता है? Doctrine in this case is a framework that is established. So, doctrine of indoor management says a person dealing with the company need not inquire whether internal proceedings relating to the contract are followed correctly once they are satisfied that the transaction is in accordance with the memorandum and the articles of association. Coming to the origin of the word doctrine, doctrine is derived from the Latin term docere, which translates to teacher. So, doctrine means teaching and learning. Now, coming to the non doctrine and the non doctrinal legal research. So, in non doctrinal legal research, it deals with the social legal aspect of research. So, non doctrine का मतलब ये होता है कि you just don't stay on what law is, you actually see its application. In non doctrinal legal research, the fieldwork is the most important part of the research, and thus इसका scope जो है वो बहुत wide है. It is more concerned with the social values. It can be a problem, policy, or law reform based. Non doctrinal research can be qualitative or quantitative, and it can be a part of a larger scale project. Now, coming to the doctrinal legal research. Now, in doctrinal legal research, the central question of inquiry here is what is law on a particular issue? It is concerned with finding law and analyzing it and coming up with the reasoning behind law कि इस law के actually में ज़रूरत क्या पड़ी. So therefore, it immensely contributes to the continuity, consistency and certainty of law. Basic information for doctrinal legal research can be gathered through primary and secondary sources. However, research has its own limitations. It is very subjective in nature, that is the doctrinal legal research, and it is limited to your perception or the perception of the researcher. It doesn't uh, give a lot of importance to what law is in application. It doesn't see the application of law, it just sees that why this law was necessary एंड इसको कैसे लाया गया एंड इसके इम्पैक्ट्स को ये नहीं देखता है. तो इसमें आप मटेरियल कहाँ से ले सकते हो. डॉक्ट्रिनल लीगल रिसर्च इज ऑल्सो लाइब्रेरी बेस्ड रिसर्च मेथड एंड दैट इज़ वाई इसका मोस्ट जो मटेरियल होता है कैन बी फाउंड इन बुक्स जर्नल्स एक्सेट्रा. As you can see, the methodology of doctrinal research. So, doctrinal research, also known as library based research, is the most common methodology employed by those undertaking research in law. The researcher here asks, what is the law in a particular case, as I've already said. It is concerned with the analysis of legal doctrine and how it was developed and how it was applied in present day. It doesn't see the implications of that law. As it is well known, this is purely theoretical research. That is, it consists either of simple research aimed at finding a specific statement of law, or it goes through a lot of analysis with more complex logic and depth. In short, it is library based research method, and here you just want to find the right answer to your question or certain legal issues. The aim of this type of methodology is to make specific inquiries in order to identify specific pieces of information. So आप information कहाँ से gather करेंगे? As I've stated, dictionaries, books, journals, research papers, all these can be referred to when you're trying to do a doctrinal legal research. Now coming to non-doctrinal legal research. Non-doctrinal research, also known as social legal research, is research that employs methods taken from other disciplines to generate empirical data that answers research questions. It can be a problem, policy, or reform of the existing law that you want to research on. A non doctrinal finding can be qualitative or quantitative in nature, and a dogmatic non doctrinal finding can be a part of large scale project, as we have already mentioned earlier. So, the non doctrinal approach allows the researcher to conduct research that analyzes the law from perspective of other scientific disciplines, such as you can say economics, psychology, sociology, and then you apply those disciplines in drafting of law. So non-doctrinal research क्या होती है? In non-doctrinal research, you just don't see what law is or how law was developed. You don't just go to the history, but you see its implication in the present day. Now, for example, in behavioral sciences, there is standard form of consumer contract that contributes to the study of psychological phenomena. Now you know कि आप contract जब भी sign करते हैं, you do a lot of it. You don't just do it specifically. Now you make even the smallest purchase that can also be a part of contract. You buy anything online, उसमें भी जब आप I agree click करते हैं किसी भी चीज़ पे, that also is a standard format. Now when you're studying or when you're doing, let's say, non-doctrinal research, you take that standard form of contract and include behavioral science in it. So what do you get as a result? You see the tendency of the customers is that they do not read the standard form of contract. They don't go word to word behind every smallest alphabet or every comma. They don't even give lot of time at reading it. Then you'll see that a lot of customers have the inability to evaluate the terms even if they do try to read it, because since it is written in legal language, not everyone is able to understand it. Now the third finding that comes out is that the ability of the sellers to deal with the consumer, because it uses non sectarian legal experimental data. It provides vital insights about the law in context, that is, how law is working in the present world. In this case, law is the standard form of contract. Legal research here is experimental, and that is why you get both qualitative data and quantitative data in this. Now, let's see the differences between doctrinal and non doctrinal legal research. Doctrinal legal research, as you can see, it is a theoretical research and more of library based, and non doctrinal research, on the other hand, is more practical in nature. Doctrinal research is based on secondary sources such as article, commentaries, textbooks, journals, etc. But non doctrinal research is based on primary sources such as case study and fieldwork and surveys. Now, doctrinal legal research is also known as library based armchair research because it does not involve going in the real field. And non doctrinal research, since it includes fieldwork, it is not called the same. So, doctrinal legal research is more concerned with the question of what is law and studying law exclusively. In this, we see the background, what happened, what was the history, and what was the need of the law, and finally, how this law came into force. In non doctrinal research, we see the connection of law with societies. It includes connection of law with various non legal aspects as well. Then the last point is that in research, the scope of doctrinal research is narrower concerning law in isolation, and in non-doctrinal you see that the scope is much wider because it studies laws in a comprehensive term. Now, before we conclude this topic of the difference between doctrinal and non-doctrinal and this whole thing कि आप रिसर्च कैसे करें, the conclusion of आप research कैसे करें basically is, firstly you'll have to identify your question and see कि कैसी methodology अपनानी है आपको, whether doctrinal, that is your research will be based fully upon textbooks and the data you get from articles and commentaries and other journals, या फिर does your question involve going to the field. If my question per se involves कि what was the employment crisis faced by migrant workers during COVID 19? I cannot just do this sitting in library and reading articles or textbooks or commentaries. Now this is a practical question. This involves going to the field, taking surveys, asking questions to people, that is migrant workers. So here I'll apply a non-doctrinal research methodology. Say for example, my question on the other hand is the force major clause in contract. Now, if it is just the force major clause, I can do a doctrinal research, that is a library based research, where my research is solely based upon commentaries, articles, and textbooks. Since that is something that you can gather from there, it does not involve a lot of field work. So, for doing the right type of research and for writing a good research article, you need to first identify whether your question is of the doctrinal category or the non doctrinal category. Now, coming to the third part of our presentation, that is article writing slash essay writing. So, article writing and essay writing, these are some things which a lot of law students do as they're doing their degree or while they're graduating. You write a lot of articles, you write a lot of essays, and even if you don't expressly write them, you do that while you're doing your assignments. Your assignments kind of are in the similar format of that of a essay or article. You begin with the introduction, you deal with the history, background, facts, issues, and then comes the relevant topic or the relevant case laws which you'll write, and then you'll give a conclusion for that topic. So legal research and legal article writing are a part of your day-to-day lives more than you can know about it. But what makes an article efficient and effective? That one thing which will make your article a lot better than others, obviously, is your research. But other than that, is the structure which you follow. So I'm not saying there is a right way or a right path which you need to follow while doing that. But as of how many articles I have written and I have read and I have seen, some things that I've always observed is that they have one structure which they follow. The first is to begin with a quote or a legal maxim or any quote of any eminent person or any you can also write, for example, say a tagline that you read in newspaper, any recent one which is relating to your topic, that gives a first good impression that yes, this person has knowledge of the topic, and it also makes your topic more interesting. The second thing is introduction. Now, introduction means you'll not just introduce the topic, you'll also include a little bit of the history. Then comes the background. Background, say for example, I'm doing doctrinal legal research, so my background will be the history कि अगर say for example फोर्स मेजर क्लॉज है तो इस क्लॉज को लाने की ज़रूरत क्या पड़ी. That will be the background slash history. Then comes the issues part. So in issues, you uh the issue, for example, my issue in the same force measure one is the importance of force measure clause. So I'll write that issue, that is the importance of force measure clause, and uske niche to support the importance or support my statement, I'll write the statutes and relevant case laws that I have found through various journals or various online platforms like Manupatra and SSC Online. After that, if my research involves a question ki whether or not this should be there or this should not be there, then if it is a yes or no question, then comes the point where you add solution and suggestion. The solution being, if there is a problem, you write a solution for that, or if there is not a problem, then you give your suggestion ki how can this law be made better, or what changes or what reforms are needed in that law. And conclusion, ऊपर की जो सारी चीज़ है up to point 6, that is something which you can gather from various sources, say textbooks or surveys or commentaries or journals or Manupatra, SCC online and other stuff like that. But जो conclusion वाला part है, it is totally what you have understood. आपने जो रिसर्च किया उससे आपको क्या समझ आया, और आप कंक्लूड क्या करना चाहते हैं, बताना क्या चाहते हैं अपने ऑडियंस को जो भी वो पढ़ रही है. So following this structure gives you a lot of marks, And if it is a competition, and even when you are writing your answers, try to write your answers in this format for better marking. This is something that always works. Now something, there are a few things which you need to avoid while writing your articles. Now अगर एक टाइम लिमिट है, से फॉर एग्जांपल आपका पेपर ही चल रहा है, उसकी टाइम लिमिट 3 घंटे की है, you cannot spend all your time in doing this thing and all your time in analyzing. You'll have to know how to manage your time efficiently. Say there's an article writing competition going on and you have 1 week to submit your essay. So you'll have to manage your time in such a way कि maximum 5 दिन में आपका article पूरा हो जाए, and on sixth day you're able to take reviews from your peers, your seniors, or your teachers, faculty members, or even your family members. You can take the review on sixth day, and then you can sit and edit it if you feel that what they are saying is there or not. If they're saying कि अरे यार इस आर्टिकल में ये चीज़ लैक कर रही है, then you can work on it because you still have another day to submit it. तो टाइम लिमिट हमेशा ध्यान में रखिए. फॉलो स्ट्रक्चर, the basic structure: introduction, background, history, the issue, the case law, the statute, the solution, and the conclusion. ये structure अगर आप follow करेंगे, then you'll get a lot of marks if it is a competition. And even if you're writing question answer, say during your exam, following this structure will give you a lot of marks. Then what often happens is that डाइवर्ट हो जाते हैं लोग टॉपिक से. यू स्टार्ट राइटिंग ऑन द टॉपिक and then you get stuck so much on one point that you completely get sidetracked or derailed. So please do not get derailed while writing your topics. Stick to the point. Use very simple language जो सबको समझ आए. Yes, as a law student you'll have to use Latin maxims, but wherever you do use maxims, उसका मतलब भी साथ में लिख दे, so that people are as a common prudent man, general man. I am not a law student, मुझे आपका आर्टिकल पढ़ना है, I find the topic interesting. अगर आपने उसमें बहुत सारे क्रेजी इंग्लिश जार्गन्स भर दिए या फिर बहुत ज़्यादा मैक्सिम भर दी, तो मुझे समझ ही नहीं आएगा. व्हाट विल बी द यूज़? सो अगर आप मैक्सिम लिख भी रहे हैं तो काइंडली एक्सप्लेन इट. यूज सिंपल लैंग्वेज. इट इज़ अ मिथ कि अगर आप कॉम्प्लिकेटेड इंग्लिश यूज़ करोगे तभी आपका आर्टिकल नंबर 1 या नंबर 2 पे आएगा. ऐसा कोई बात नहीं है. इवन यूजिंग सिंपल लैंग्वेज विच पीपल अंडरस्टैंड, that is the main key to winning a competition. Using simple language which people understands and by which you are able to express your ideas clearly. This is something that everyone must work on, I believe. And don't run away to use fancy jargons that won't give you anything. Now अगर आप article writing कर रहे हैं, another important rule which you need to follow is of citations. So अगर आप कहीं से कोई भी किसी का टेक्स्ट रेफर कर रहे हैं, प्लीज cite that because you are using someone else's work. Now say for example today your work is published and कल किसी ने आप ही का वर्क उठा के अपने आर्टिकल में डाल दिया. You will want the credit. You wouldn't want कि आपका वर्क का क्रेडिट किसी और को जाए. सो थिंक दैट. एंड इसीलिए अगर आप भी किसी का वर्क रेफर कर रहे हैं तो प्लीज साइट दैट प्रॉपरली. एंड ऑलवेज इफ यू आर पार्टिसिपेटिंग इन एन कॉम्पिटिशन, always read the rules twice or thrice, go through it thoroughly. And most competitions have a rule कि आपको कैसे cite करना है, तो उसी हिसाब से cite कीजिए. because even if you do not cite correctly or you make a mistake in that or use any other format, say they have said Harvard Blue Book 20th edition and you cite it in any other XYZ format, तो इससे भी आपके मार्क्स कट सकते हैं. सो टेक अ नोट ऑफ दैट टू. Now, since we are talking a lot of legal research and legal article writing and those things, it also helps you during your internships. So, at Legal Vidya, we provide these five roles for our interns. The first is legal news team. The second is legal research team. The third is case analysis team. The fourth are blog writers and the fifth are social media marketing team. तो लीगल न्यूज़ टीम क्या करती है? तो आई एम श्योर कि सबने देखा होगा कि रोज़-रोज़ लॉ की हज़ारों न्यूज़ पोस्ट होती है वेबसाइट्स पे, न्यूज़पेपर्स में। सो लीगल न्यूज़ टीम उसी न्यूज़ को पढ़ती है, उसे अपने वर्ड्स में एक्सप्लेन करती है, मेक्स इट ईज़ियर फॉर एवरीवन टू अंडरस्टैंड एंड पोस्ट्स इट। ऐसी सारी टीम्स का अपना-अपना रोल है। So if you wish to apply for internships at Legal Vidya, you can send your CV at contact@legalvidya.com or legalvidya@gmail.com, or you can visit our website, that is www.legalvidya.com, and submit your CV on the internship page. Now that will be for this video. Thank you so much everyone.